ladies and gentlemen, why don't we get started? Thank you all for coming today. We appreciate it to have what I think is going to be a really interesting discussion about the territorial disputes in the East China Sea. And we've labeled this as Northeast Asia headed towards war, but I want to talk a little bit more broadly about what we're hoping to do today. My name is Michael Auslin. I am a resident scholar here at the American Enterprise Institute, working on Asian security and political issues, and we've put together just a great panel to explore this rather controversial and contentious topic from a slightly different angle than what we usually do. Many of you who come to our events or go to the events at other think tanks know well that we often have a overwhelming focus on security, number one. Usually hear from people in think tanks or academics and the like, and so we thought we'd do something a little bit different. My colleague John Yu, whom I'll formally introduce in just a second, had put together a conference out at Berkeley earlier this year, or I guess late last year, can't remember, sometime recently, to talk about these issues from the legal perspective. Again, which is something that in DC often, even though these at base are legal disputes, is something that often gets ignored. And so we had a phenomenal table, a private conference of worldwide legal experts, most of whom were from Europe, talking about the different legal concepts related to territory and unclaimed territory and partially claimed territory and the like. It was a very different approach than we usually take here, and John thought it would be a good idea, and I heartily agreed to bring it out here to DC and approach it initially from that perspective, which is to lay out these contentious issues over island disputes, particularly the Senkaku dispute between China, Taiwan, and Japan, and then the Dokdo Takeshima dispute between South Korea and Japan from the legal perspective. But then, again, to change it up a little bit, from instead of usually just having a think tanker who deals with counting Navy ships coming out and talking about it, we thought it'd be great to get the Hill perspective and get the perspective of people who are really dealing with this from the policy angle and what they think, how they interpret it, how they balance the competing claims and their own assessment of what is the right way forward and what is the position the U.S. should take. And so we have just a wonderful group of experts here today, and I'm going to introduce them first, and then we'll have each of them speak for a few minutes. I'll moderate a discussion, and then we will open it up to you all for a broader discussion. Sitting directly to my right is John Yu, who has been a professor of law at UC Berkeley since 1993, believe it or not, which is a long time, John. But of course had a stint here in DC, so is well known in DC as the Deputy Assistant Attorney General in the Office of Legal Counsel in the first Bush administration from 2001 to 2003. He's just released a book, which he had an event on here yesterday at AEI, called Point of Attack, Preventative War, International Law, and Global Warfare, which I highly encourage you to pick up and take a look at, because it's a definitive look at those issues, and particularly going forward. Sitting next to John is Sean Callahan, who is the Senior Military Legislative Assistant for Representative Colleen Hanabusa from Hawaii. He focuses on defense and foreign policy. He has done other work in the private sector as well for Halliburton. He has wide-ranging experience outside of Asia, including Africa and the Middle East, and worked with the U.S. Army, and also served in, thought I heard that, but worked with the U.S. Army as well. And then batting cleanup today is someone who's no stranger to AEI, Eric Sayers, who we know and has visited us lots of times here, and we always appreciate that. Eric is the Defense Policy Advisor to Representative Randy Forbes, who's also a good friend of ours. And in fact, Representative Forbes and Representative Hanabusa released a Asia-Pacific strategy document the other day that was based on a series of hearings and other activities that they had. And in fact, we helped kick off that series here with Representative Forbes a few months ago and had an outstanding discussion with him. Eric has a wide experience working in the policy world, working at think tanks, and writes a ton, which is relatively rare for folks on the Hill, but is widely known with throughout the policy community. So just three great people to talk about this issue, which we all recognize, by the way, is contentious. We know there's a lot of controversial different viewpoints on it. But what we want to do is cut through some of the fog of it all and get down to the core legal issues and then really take a look at what it means from a policy perspective. So with that, I'm going to turn it over to John Yu.
Thanks, Misha. Thanks for putting this panel together, and thanks for your interest in figuring out these island disputes and their legality and their practical political importance. It's great to be here at AEI. You said I'd been teaching at Berkeley for 20 years. This is my 10th year at AEI, and it's like I was saying yesterday, it's like your home away, my home away from home. So it's great to be here. I'm really grateful for the presence of the two panelists. I was a Hill staffer too once upon a time, and I know to take an hour and a half out of your day is a really big deal, so I really appreciate that you're here, and I really look forward to hearing what you have to say in your perspectives on this issue. And as Misha suggested, I think the legal issues are interesting. The political and military importance of these issues, of course, is paramount. No one, and this goes to the legal issue, really wants to. No one wants to see any kind of military conflict in this region over these islands. At the same time, the countries involved, Japan, China, and Korea, take some fairly aggressive measures, involving ships and people, and you could see or you could worry about something spiraling out of control. And so I thought maybe one thing it'd be interesting to do is go through the legal arguments as a setup to figure out, well, once these countries have made their legal positions, how does it get resolved? And that may, I suspect, never happen in a court. But at the same time, one thing I've noticed, I don't know what you all think, is that the countries in all of these actions are trying to do things to bolster their legal case to the islands. So when you read about the different countries stationing ships in places, or trying to establish facts through archaeological digs, or setting up the air defense zone that China just announced that includes the Senkaku Islands, those are all things which form evidence for legal claims. And so it seems to me suggests that the countries themselves think about the legal claims as much as, or at least close to, the way they also think about in terms of the politics and the military issues. So with the Senkakus and the Dokdo Island, I'll call one by the Japanese name and one by the Korean name, just to rather than repeating two names for each island. The legal claim, actually, I think, made by Japan is very similar in both cases. And I had always, I had not taken as close a look as I should have before I got interested in this issue. But they're built on very unusual arguments, but I think there's an important difference in the legal claims. And I think in the end, the Japanese claim as to the Dokdo Island, the one that they dispute with Korea, is weak, but it's stronger when it comes to the Senkaku Islands, even though they're very similar claims, because, and this is a political issue in a way, because of the way that World War II ended in the Pacific. Let me just explain this a little bit, Bob, try to do it quickly. Both Korea and China claim that they both discovered these islands long ago, hundreds and hundreds of years ago, with Korea, maybe close to 1000 AD in the case of Dokdo Island, with China at least in the 1400s, if not earlier, with the Senkaku Islands. And so under international law, generally the way you come to possess territory is you discover it and then you maintain control of the territory. And so both Korea and China claim they found these islands long before Japan knew about them, and that they continuously exercise some amount of government power over the islands. And then at the time of the late 19th century, possession of both islands changed in a series of wars. In 1895, there was the war between China and Japan. There was a treaty, the Treaty of Shimonoseki. I don't know if I'm pronouncing it right. Misha has full authority to correct all my pronunciation. He pronounces, I'm sure, Korean better than I do, and Japanese and Chinese. So the Treaty of Shimonoseki ended the war between Japan and China. With Korea, there was a series of legal documents which led up to the annexation of Korea by Japan in 1910, but there were earlier steps in 1907 and 1905. In both of those cases, Japan could have made the claim that they had actually conquered the islands as part of the territorial spoils after the end of the war, but they didn't. Instead, the Japanese made a different kind of claim And I think it's a difficult claim. It's a claim that both islands were what in the law we call terra nullius, which means it was unknown, that no one had ever possessed the islands. It's sort of similar to the legal doctrine that the Europeans claimed about North America, or the Americas when they were found, that in other words, that the Japanese were really the first people to discover those islands, and so they could claim discovery of them. It wasn't that they had conquered them from Korea or China. And the reason this is I think, an unusual argument, but I think the reason why it has to be made by Japan is because of the unusual way that World War II ended. Because throughout World War II, there were a series of declarations, the Cairo Declaration, Potsdam Principles, and in both of those documents, the Western Allies declared that the peace settlement in the Pacific would require Japan to return all the territory that they had conquered. And so if Japan had said they had conquered these islands, they would be included in all of the things they had to give back. But if they said they found the islands and they had never been taken away from China or Korea, then they wouldn't be included in the scope of the Allies' demands for the end of the World War II peace. And so it's a very unusual legal argument. There's a lot of, I have to say, the terra nullius doctrine in international law is very controversial. It's not been applied very often because it has been wrapped up in a history of sort of Western imperialism and colonization. And the other problem with it is easily disproved, because if you can show using archaeological evidence or historical records or maps held by third countries that you had actually, that someone else had been there before you claimed it to be terra nullius, then the claim is easily defeated. But I think that's why Japan makes the claim in this unusual way, because of the nature of the World War II settlement. But then let me just focus on why it's. And let me say, as sort of my own opinion, just looking at the evidence, I think it's very hard to claim that either island was unknown and never found, because they do appear on maps from before this period. There are records in both governments that talk about these islands and visits and efforts to exercise sovereignty over them. So I think it's very hard to make this terra nullius claim. But I think there's a big difference between the Korea and Chinese claims when it gets to the end of World War II. And I think that will end up becoming the real focus. And this is why I think it becomes really political, because a lot of the other issues, comfort women, reparations, a lot of it has to do with the sort of unsettled nature of the peace that ended up at the end of World War II in the Pacific. As you may know, that was done in the 1951 Treaty of San Francisco. And with the dispute between Korea and Japan, the 1951 treaty said Korea is to be freed, the territories to be returned. The treaty does not specifically list the island of Dokdo. It lists other islands. And the argument is just, was Dokdo such a small island they didn't feel like including it in the list? Or was it an island that was originally discovered by Japan and should be kept by Japan? I think, though, with the 1951 treaty, even if it doesn't mention the island, then it just reverts back to the question of who found it in the first place. And so I think that's why I think the Korea claim is much stronger as to possession of Dokdo. The Senkakus is very different, because what happened in the end of World War II, unlike what happened with Dokdo, with the Senkakus, the United States actually took possession of the islands at the end of World War II. And so it was never in China's possession at the end of World War II. It was never returned to their control. Instead, what happened is that in the peace treaty of 1951, the peace settlement gave the United States the power of occupation of these islands. And it was the United States eventually returned it to Japan in 1971, along with the return of full sovereignty over Okinawa. And so the Japan claim about the Senkakus would be that this period between 1945 and 1971 gave the United States power over the islands, that they had won them at the end of the war, and then it was up to the United States to give them to whoever they chose, and they chose to give them to Japan. Now, the big problem legally, and this will now, I think, get to the other Japan, is that neither China nor Korea ever signed the 1951 treaty. Right? It was a treaty between the Allies and Japan. China refused to sign, Korea did not sign, and so there's this very important international legal issue about whether they're bound by the terms of this settlement at all. Right now, there's good cases on both sides, but both countries say, look, we didn't get a chance to sign, so how can you dispose of what's supposed to be our territory through a treaty that we never participated in? You can see why that has less force with the Senkakus, because if the U.S. came into possession of the Senkakus, then they can say, well, we could give them out. It doesn't matter if China never signed because they weren't Chinese. Now, I take it the U.S. government position, I'm curious to know, I think in both cases, is they're now both ambivalent. The U.S. is saying we're not taking a position, it's both ambivalent. So let me end there and just end it with the idea that, again, I don't think that any court is eventually going to decide. You could take these to the International Court of Justice, but you need both parties, both sides to agree, and that's very difficult to do in both of these disputes. You don't have that. One of the two countries objects to taking this to a court. I think with DOCTO, Japan wants to take it to the courts. Korea refuses. With the Senkakus, China wants to have a legal proceeding, and Japan refuses. So it seems to me unlikely that there'll ever be a formal legal proceeding to decide this. It will ultimately decide through political means. But the thing that's interesting, I think, is the political and the legal are mixing. Is something I just referred to in the beginning. That with the air defense zone, for example, is a good example. Air defense zones don't really exist under international law. You could say it's just a matter of your fighter just following along in open airspace with other people, and you're just telling people you're going to do that. But it's also a way of trying to show that you're in a sort of slow, incremental way establishing more and more control over territory. And so it seems to me sometimes you might interpret things which look very aggressive and hostile from a military perspective. Some of these countries might be really doing them to build this kind of legal case and a political case to show why they should be given possession of the islands. So thanks a lot. I look forward to your comments and thoughts. Thanks, Michelle.
John, that's great. Exactly what I hope we do. It just started off on a different angle, and your key point about that the things that we all focus on, how many ships are going where and planes are going where, may actually be done for legal claims. And that's something I think that often, not always, but often gets lost in D.C. So shifting as you did, you shift us towards policy. I'd love to turn it over to Sean.
Thanks, and I appreciate everybody having me here today to be in the esteemed colleagues to my right and left. So I think when you look at the title of this panel, is Northeast Asia headed towards war on the high seas? I think it's incumbent upon anybody who represents the U.S. government to ensure that doesn't happen. Asia Pacific, in particular, East Asia, it should be one of the number one priorities of any U.S. administration. If the title of this panel were to come true, the economic consequences alone would be greater than the 2008 recession, would have global impacts all over the world, not just regional. So I think that it's questionable right now, looking at it from a policymaker standpoint in Congress, whether or not that is one of the top priorities. I think we need to build on the president's recent visit and really focus on making Congress look at the whole greater impacts of the Asia-Pacific rebalance a priority, which, as Misha mentioned earlier, Mr. Forbes and my boss, Ms. Hanabusa, we just introduced a bill on Monday that tried to get at some of the different things of putting a policy document out that outlined where more rapidly where the U.S. stands on some of these. It was called the Asia Pacific Region Priority Act. But I think, just to go back, John just gave an intricate breakdown of the legal aspects of the different territorial disputes and challenges in East Asia. And the reason it's so difficult to get this focused on in depth in Congress is because I think many of the people that set the policy in this area don't have a holistic understanding of some of the challenges in historical policy in the region that John just broke down. I mean, how many members of Congress are aware intricately of the historical beginnings of the disputes in the Senkakus? Or I'll follow him and call doctos, use one of each. We've spent the past 2 decades embroiled in the Middle East and fighting 2 different wars, so it's hard to, without the holistic understanding of where this all resonated from, to get people to actually focus on creating policy that forwards U.S. priorities in the region. I think to do so, the U.S. has to put out something that's clear in the message of our position in gray areas, clear on the message to our allies and partners in the region. Because all claimants to these territories are going to continue to push limits until they're confronted. They're going to continue to escalate and be more confrontational. And there's no single policy document that's come out of the administration, that's come out of any branch of government that really outlines where the U.S. stands on these. As John mentioned before this, we're sort of ambivalent to the claims. We believe that administrative control of the Senkakus places the Senkakus under our treaty alliance with Japan. But there's no bigger document that speaks to U.S. policy on these disputes and how we would react whether we were faced with a heightened confrontation. I believe that certain questions need to be answered. When we look at the different claimants to all of these, we're not a party to the Convention on Law of the Sea, though that is the international legal document that we use to refute many of the claims when we assert that one of these claimants is overreaching what they're legally entitled to. The interpretation of military rights in other countries' exclusive economic zones, I think the U.S. has to be intimately involved in crafting that interpretation, and without being a party to the policy document that outlines many of those claims, it's hard for us to refute oversteps in those boundaries. I think that, from a greater force structure, although we're talking about the legal disputes, there's a question of whether the U.S. is committed to backing our allies, and many times, as Misha mentioned, we count ships. I think we do that because the military is the most visible component of U.S. government policy in the region. And I'd like to emphasize that, though I don't think our force structure is perfect by any means right now, you have to emphasize capabilities over numbers and look at capabilities over just posture and sheer numbers of ships. If you look at some of the upcoming initiatives that will be done in the region, the Joint Strike Fighter, it's going to be based first in Japan. Additional subs to Hawaii and Guam. The Zumwalt is being discussed at the DDG-1000, the latest class of destroyer, is being discussed as deploying to Japan first. And then other assets is the LCS to Singapore. So I think our commitment and investments have to be right to demonstrate that we are committed to the region. And with our regional partners and allies, many of which share overlapping claims to the territories that we're discussing right now, we have to find ways to encourage cooperation. We've stayed wholly transparent on the Dakto Islands issue and encouraged two of our staunchest allies in the region that they need to work it out together. Stay neutral with our allies and dismantle the hub and spoke system that's been the formation of U.S. policy in the region so far, so that we can come to terms to engage and work on regional disputes in a more multilateral fashion. I think that supporting regional forums are important in this, and I think that if we look more to dealing with these disputes in a more broad swath rather than bilaterally, I think we can have a lot of effect. But I think the main thing, just to go back to and to sort of sum up my remarks, and I look forward to discussing some of these more in depth, is that there's no central document that we can refer back to for what U.S. policy is in the region. There's nothing that's out there that outlines where we stand. And I think that to be successful in intervening or to be a successful participant in any of these, we have to have that and really outline where we stand. So with that, I'll pass it over to Eric, and I'm sure he's got some stuff to follow up on. So.
Sean, that's great. Thank you very much. Eric, you're batting cleanup for us.
Sure. As cleanup too, a lot of things have already been mentioned, so I'll try to just jump into some of my main points. And first, thanks to Misha, who's been a friend and a mentor the last few years, and also a good friend of our office, as he mentioned. Mr. Forbes has co-authored with him before, and we looked to him for some guidance on a variety of these issues. My experience with this issue, I'm a little bit atypical of a Hill staffer. I was in the think tank world before going to the Hill about 3 years ago. And I spent a year as a fellow with CSIS, focusing actually on the strategic geography of the East China Sea, what we're talking about today. So I had the opportunity in the fall of 2010 to travel there, to spend about a week in the region in Okinawa, but also down into the Ryukyus, the southwestern kind of chain of the Nansei Islands, and to go to Miyako-jima as well, one of the islands that sits just to the east of Senkaku, and to visit there to see some of the military facilities, and to actually do what was a State Department-led discussion with some of the local Miyakans, who are, many of them fishermen. We had 50 or 60 people show up and really we did an hour and a half, kind of a 90-minute discussion to hear the issues that they were facing and how they thought about the alliance and issues like extended deterrence. And so through that research, I spent that year really looking and asking some of these questions. Why this region? Why so much focus? My conclusions were really that it was being driven by strategic geography. Some of the legal elements, some of the military elements, obviously the nationalism and the gas and mineral opportunities that exist in that region, all have been factors that have been discussed. But what really explained to me why in the last 5 years this has become one of those issues that's at the forefront, and why in the last 2 years or so it's on the front of a lot of international papers, was the strategic geography of the region. I did a lot of reading of Mahan and some of the things he had written 100 years ago about the strategic importance previously of the Mediterranean Sea and how that was kind of a central fault line for great power competition. And then in Mahan's day, the Caribbean Sea, and how at the turn of the century you had some of the great powers still in Europe and the United States as an emerging great power after the Spanish-American War, all looking to the Caribbean Sea and the Gulf of Mexico as a place for setting up bases, for competition, and as a secondary factor is the resources and the trade that was available there as well. And I saw, Mahan said, the portions of the Earth's surface and their consequent interests to mankind differ from time to time. And I saw through that an article he wrote specifically where he said that, and some of the competition that was emerging in between the United States and China being played out in this maritime environment, in the East China Sea, and specifically along kind of this northern chain of what the Chinese call the First Island chain. And that was really a driving factor in explaining for me why the other elements of the competition were being driven the way they were. It was power, essentially. It was the last 5 years, and as is common knowledge and discussed at think tanks, the emerging of China from the Great Recession, and what they saw as a strengthened position, with a military that had been modernizing quite aggressively for the previous 10 to 15 years, and an opportunity to press that situation across the First Island chain in some of these disputes that they had with a variety of means. But how is that competition being played out? The title here, as Sean mentioned as well, is War on the High Seas. I certainly don't think that's really the discussion point. For me, it is, and this certainly isn't Cold War terminology, but for me it is a competition between an emerging great power, a current great power, being played out under a nuclear weapons umbrella. And so just like in the Cold War, a lot of that competition was played out with legal means, and with diplomatic means, and with intelligence, in the modern case, cyber, and a variety of other pieces of this puzzle. And I think that's, to kind of summarize where I'm coming from on this, I think the geography element, the strategic geography element, is really what explains, or is the primary factor that explains why the Ryukyus, why the southwestern islands of Japan now. The Congress's role in this, I agree with almost all of what Sean said. It is certainly on the radar, but we have more and more in the last 2 or 3 years, the Japanese ambassador, the Korean ambassador, representatives from TECRO in our office talking about these issues. We have delegations of members from the various parliaments in and asking to see our bosses, who are become kind of some of the leading faces on the House side, several times a month. Our bosses both sit on the Armed Services Committee, and so the primary lens that we can kind of help in this issue kind of day to day is setting the longer term trend lines for the military side of things. I don't want to get into the wonks, discussions of platforms, but for my boss and for me as well, you got to always be careful in these things. Represent my boss and my own opinions, but his opinions continue to drive what I can say today. There's 2 issues that are facing the United States in the next couple of years that are sort of driving U.S. defense policy in ways that we can approach this. One is just the trend line of the larger defense budget. The sequestration caps have been relieved a little bit this year and next year, but are hitting in a way now that is forcing the Congress to make very tough decisions, which, as we know, gets decided in all the ways that it normally gets decided, through politics and district politics and national politics. And so as long as those trend lines are in the direction they are, it's placing immense pressure on the defense budget and our ability to kind of invest in some of those capabilities and platforms that we really think need to be prioritized in the next 10 years for Asia Pacific. The aerospace capabilities, the maritime capabilities, some of the long-range strike at the high end. I view sort of the U.S. role in the region as one, maintaining kind of that high-end escalatory capability all the way up to the strategic kind of nuclear deterrent level, and then in a sort of bifurcated way, allowing and enabling and finding ways to enable our allies to deal with some of those peacetime competitive elements, the gray zone, as we've all been saying, and the Japanese have been talking about the last 6 months to a year. The second element of that is if this top line is going to be where it is, where it's locked in, we're going to have to talk about the shares of budget portfolios. We've generally, the last 30 or 40 years, you can look at the charts, there's always ways to kind of refute this, but the services receive about equal shares or fair shares of the budget. That kind of keeps, and this is especially the case since Goldwater Nichols in the late 80s, that keeps the peace over in the building. But if these caps are going to stay in place for the next couple of years, and we're going to continue to work to try to change them and change those trend lines, we're going to have a serious discussion about how we do strategy and how that strategy drives our priorities and our investments. My boss's thinking is that if Asia Pacific or PACOM is going to kind of be number one in priority, then maritime forces, aerospace forces, and I include in that kind of cyber and space as well, should be prioritized. Just funding the shipbuilding budget, is not a huge lift. Ron O'Rourke at CRS has testified to us. We're only talking 1 to 1.5% of the total DoD budget needs to get shipped over to do everything the Navy wants to do in its shipbuilding the next 15, 20 years. So we really think that discussion needs to be had, and you can see clearly from the QDR, the Defense Strategic Guidance, just those two documents of the last 2 years, that it sets the sail, it sets the ship in that direction towards prioritizing those forces, but we haven't seen that necessarily at the back end. It seems to me that each of the services is taking pain in their own way. It raises a couple other questions as well, and in the few minutes I have to kind of close. I think we're hearing a lot from the different embassies about reassurance, and often the Hill hears that even more when they're not getting what they think they are entitled to, I guess, from the administration. They're not getting the level of reassurance that would make them or put them at ease. And so I think that is what's explaining, this constant march up to the Hill to talk to us and try to get things like this bill that we did and some strong language that we did in there we thought was necessary. But there's also a balance to that I think is important. At the same time that we're trying to reverse those trend lines and the department's trying to communicate to the Hill the risks inherent in the budget numbers that we're locked into, and risks that are medium to high level in some cases in places like Asia, as they've testified to. We also have to continue to reassure our friends and allies that we'll be there, we're there, nothing to worry about. This is a difficult balance, and I think as I've talked about this in a number of conferences, and my boss has as well, it's becoming upon some of the capitals in Asia to understand the political dynamics of our own defense budgeting here in town, that we would like to reassure to the extent possible. At the same time, we need the department to very vocally talk about that level of risk that we're walking ourselves into. That's the only way that you're going to get the broader Congress to accept that this is an unacceptable path. And so that's an important balance that I think we need to communicate better to our allies and on the Hill as we sort of work through the remaining 7 years, unfortunately, of sequestration. Finally, on the broader kind of Congress in Asia and the focus on Asia, one of the beats I've been on recently is just talking kind of continually about the last decade, just as we're trying to sort of rebalance the executive branch, the administration, time, energy, and resources towards Asia Pacific. And I hesitate to use rebalance and pivot. I think that describes more of a grand strategy than necessarily a regional strategy. I prefer from a defense perspective to focus on the balance of military power. And if that's shifting, then we should be having serious discussions about shifting resources. But one of the things that the Congress does is it aligns well with where the administration's going. We, on the Armed Services Committee, as well as the other committees that focus on foreign policy, they very much structure themselves to do oversight of the primary issues that are facing our government right now. And so the last 12 years, to no surprise, the committees, from a staffing perspective, from an oversight perspective, I'm talking about hearings and kind of legislation, they focused on Iraq and Afghanistan and counterterrorism, the war on terror. No fault. But as we're shifting and the Hill's trying to get smarter about what it can do to follow where the administration is saying they'd like to at least go and help our allies in PACOM kind of get the resources they need to get, it's going to be really important to not only get the members at the high level to understand these issues that's going on, but to structure the committees, the Foreign Affairs committees, the Armed Services committees in a way that you have that institutional capacity. You have those staffers that understand these issues, that are out in the region kind of constantly, that are doing oversight hearings and asking questions. When I first came in, it was we only did one PACOM hearing a year, really, and that's kind of why Sean and I and our bosses got together last summer and said, hey, we got to rebalance the hearing portfolio. There is just not enough. Members, a lot of times, their attention, what they think is important, is driven by the hearings they're sitting in and what they're consuming. And so that's why we set out to do the dozen or so hearings and classified briefings that we conducted over the last 6 months. And that's what ultimately led to this Asia Pacific bill, which has a lot of strong language about how the Congress feels about maritime disputes, because we think we have a role to play in that reassurance portfolio, which has a few different ideas and areas that we need to plus things up, but also is really informed, not just the bill, but has really informed some of the other decisions we're making in this defense bill. Like I was talking about in the priorities section, there was a cut to munitions and the Tomahawk line, for instance, which is going to leave us without one of our main munitions for land attack until about the early 2020s. That's something that we decided based on those hearings and what we were hearing from PACOM that we had to find the resources to replace, and we did do that in our mark that was public yesterday. There's also a lack, in our opinion, and Sean mentioned this about, and I'll close with this, about a broader strategy focus. We've heard a lot of speeches, there's been a lot of op-eds constantly trying to reassure that the rebalance strategy is something real. For us, we've done a number of letters on this now and haven't received the most positive feedback. We think that there needs to be a unclassified document that it can explain from an NSC level or interagency level where we're going, but hopefully behind that, as we did so successfully in kind of late 70s and in the 80s, a classified assessment of the interagency focuses, the guidance to the country teams in the region, where we should be going. There are some inklings that perhaps this is going on now. We certainly want to find ways to encourage that. There's other talk of Congress doing a bill to push that, but that's a role we often find ourselves in when it comes to these kind of things. We don't want to force them to do it because we don't think the quality of that product will be good. We want them to want to do it. And so in this case, we think we're trying to stimulate enough of a push from think tanks and elsewhere to get quality product like this. Unfortunately, these things always come in the last 2 or 3 years of administrations, which it seems to be the case in this one as well. And so I'll leave it there, and we can certainly get into some of the more detailed things that I had laid out and for my opening remarks in the Q&A session. Thanks, Misha.
Eric, thanks a lot for that great overview. I'm going to ask a few questions to get the discussion going, and then we'll open it up for you all. I wanted to start with John, and since I'm not a legal expert, obviously, and most people in town really don't know the issues, but you so eloquently laid them out. May sound initially like I'm sure it is, a very simplistic question, but one that I think we covered at our conference in Berkeley, which is why so much of the emphasis on the legal claims? From one perspective, obviously, it makes perfect sense. There's a legitimacy to it, and yet, as Sean was talking about, so much of what is going on, and Eric's comments about the geography, this is really power driving this, and it's power, it's influence, it's who you can win to your side, and the like through perceptions of what the future is going to look like. I'm just wondering if you could expound a little bit more on why there is so much fealty paid to trying to win over public opinion on the legal side as opposed to maybe another approach.
It's a good question. It's a hard question. I may not be the best person to, ask about why they. I could probably talk a lot about what the claims are, why they place so much importance on it politically is a hard one. So some of it I think has to do with the nature of the legal evidence here is historical, and so when it relies on history, it raises a lot of sort of nationalistic issues. I think a lot of leftover resentments from World War II. And that's another reason. The settlement of the war in the Pacific has a lot of open-ended issues in a way that wasn't quite true of the end of the war in Europe. And because of that, it keeps a lot of the issues and resentments going. I think that's one. Right, so with both China and Korea, I think Japanese claims to these islands is a reminder of the 1890 to 1945 period in their minds. I think that's one. But I think the second thing, and this goes to something that Sean was saying, was that nobody wants there to be conflict, right? No one wants there to be a war. You look at models of how countries settle disputes, and they should settle disputes when the value of any of these islands, not the strategic value, but just sort of the actual value of the islands, and even the resources under the sea under these islands, doesn't come close to the cost you would have if you actually had a military conflict. So that would be an area where you would expect to see some kind of peaceful resolution in a permanent way. And so that would be a situation where you could see maybe some kind of arbitration or some kind of court decision, and that's when legal claims would really be important. There are examples of this happening where smaller islands and territories, eventually both countries put it to someone else to decide, and they agree to be bound by the result. It doesn't have to be International Court of Justice. Before the 20th century, they would often ask another government to decide, right? They put it to like the King of Holland or something, or the King of Italy issued a very important opinion once about who owned a certain island in Asia, right? It just doesn't, so you just have a third party do it. So I think that's another reason why legal claims can become important with these islands. And then I think I think the third, maybe, and this is more speculative, the third reason why they care so much about the law is that I think it's also maybe symbolic of, and I thought I was really interested about this rising power. It made me think a lot about Germany and World War I. A lot of people do think that, and I was like, are the Senkakus like Alsace-Lorraine, right? Like, is it going to be this weird, territorial spark that's always festering? And so, and you could look at, and this sort of bears it out, like, should the country, we should have figured out a way to avoid the war, right, in World War I by settling these, what in the end were minor territorial disputes. So the last thing I'll say is maybe the legal thing provides the opportunity for the United States to become involved in a way, because at least with the DOCTO, right, this is, I think what I took away from both your comments is that this is a dispute between allies. And that's something where you could have a negotiated settlement where the United States played the brokering role. It seems, Korea has possession. If Japan were to drop its claim, maybe the United States could figure out some other way of compensating Japan, right, with some kind of more security guarantee or something, or military aid or something. The Senkakus is different. It seems to me like when you look at the legal claims, it might be harder to do, because what is the United States and Japan going to actually offer China to get them to drop their claim? It seems harder to do because it's not an intra-alliance fight. It's about between, right, the existing great power and the rising great power. And so there's a lot more deeper strategic considerations behind the dispute. And so there maybe law won't in the end matter as much as it does for DOCTO, because there the Senkakus have less chance of a peace, a sort of intra-alliance resolution that's done with this, the United States maybe being involved.
Although interestingly, from a policy perspective, a political perspective, I think it might be harder for the U.S. to broker an agreement between two allies, because one ally is not going to be happy, most likely, and that can affect the alliance. Whereas, again, politically, I think you could see at some point in time, maybe let's just continue the trajectory of Chinese assertiveness, if not coerciveness, over the Senkakus, that the U.S. could come down and say, no, you know what? We're more comfortable making a sovereignty determination at this point, because China is clearly not respecting the boundaries of international behavior. So just as a counterpoint to how you put it, Sean, this sort of leads in, I wanted actually to ask, you mentioned early in your comments that all the claimants are becoming more confrontational. And I wanted to ask you, first of all, why you think that is. I mean, what is the failure here that they are simply not able to come to some type of negotiated or arbitrated agreement, or let's leave it negotiated. But is the U.S. strategic ambiguity partly responsible for that? The fact that we have said we will not take a position on the sovereignty claims, but in the case of the Senkakus, we say they're administered. In the case of DOCTO, we really, it's our hands are almost completely off.
Yeah, well, I think I think it actually leads back into your first question to John, and why is the legal basis and people trying to get on the legal side. And I'll premise this: I'm no legal expert, so don't quote me on any of this. But there's no real other institution or method of settlement to go to. I mean, all claimants have become more aggressive because the only real alternative to any type of legal settlement, and that doesn't work, is the saber rattling that we're seeing right now. And I don't think that any claimant out of all of them to any of these territorial disputes see leading into conflict that a military means of changing the status quo on any of these would actually be recognized in the greater global good. So I think because there is a lack of any solid legal basis to resolve the claims. There's no, third-party king of Italy that can come out and say that the Senkakus belong to Japan. That's really the only alternative that there is to sort of, go to the military and sort of try to change the balance of power through words or actions like the Chinese ADIZ or stepping up patrols near the islands. But I think that everybody recognizes at the end of the day that there would be no legitimacy, to go back to the word, if any of these the status quo was changed by coercive means or conflict. So I'd say that.
Thank you. Eric, both you and Sean talked about we need a clearer document, and that's what you, with your bosses, have tried to do. We need a strategy. The last one I can remember, and somebody can correct me if I'm wrong, I think it's the 1998 Defense Department strategy for East Asia, so that's 15 years now and counting, 15 years plus. I want to ask sort of two interrelated questions, and part of it is because you used the word reassurance, and of course the president, when he went on the trip last week to Asia, a very long trip, by the way, it's a pretty extended trip for a president to make, said this is a trip about reassurance. I mean, this was said by the administration officials, and our friends would say we want reassurance, as you mentioned, through this trip. So the first question I have is, number one, do you think he did that on the trip? But secondly, how much would a document of that type go towards reassurance? Or would it almost naturally, through the intergovernmental or the interagency process, become, a sort of anodyne, one-size-fits-all general statement of wishes, but nothing that really gets to what I think you and Sean were talking about, which is how do you drill down and get to some clarity on what our interests and responses are here?
So I think the document, I think that the important part and why we thought it was worth pushing for was more the exercise that they would go through. I don't understand. I don't believe that they have gone through the extensive exercise that you would do for a long-term strategic planning document. And everybody I've talked to says that hasn't happened. They certainly understood sort of global politics coming out of Iraq and Afghanistan, Asia Pacific, allies, and you guys know the spiel. And Asia Pacific should be prioritized, but actually how to go about that and the guidance that needs to go to the interagency and to the country teams and to the budget OMB folks, that's never been teased out. And so we thought the exercise itself or alone might help to tease out that process. The document in unclassified form, it's hard to, as the president's trip to the region, especially when the vice president went and visited China and went to all the Northeast Asian countries and has to sort of give multiple messages. I mean, that's a very difficult balance. I don't think, I wrote down the quote, the president should certainly always talk about it. Our goal isn't to contain China. It certainly isn't. If it was, we'd be doing a heck of a bad job at it, having such a large interconnected economy. But when he says things like, our goal is not to counter China either, I don't think that rings well in Japan when they're looking to us for reassurance and under the pressure they are, or Taiwan or Southeast Asia, Vietnam or the Philippines for that matter. Another dispute that we aren't talking about here today, but is certainly not independent of these other ones. I see them kind of as a collection that should be considered together and interconnected. I would say as well, to add to that on the couple different points here. On the legal side, if I could just go back to the first question, again, I'm not a China expert. I will preface it with that, but the literature I have read from Chinese scholars and my understanding of kind of Chinese historical fears and animosities, kind of strategic culture, There's always been this fear of land borders, but a lot of those land disputes were resolved in the early 1990s. Taylor Vervel has written a good book on this. A lot of the maritime disputes have not been resolved. And in kind of modern China, if you will, the last 30 or 40 years, it is more the maritime sea lines of communication and the maritime borders, if you will, that are driving, I think, Chinese insecurity, if I could use that word. And thus, a lot of what we see in the last decade, which has brought us to now where we are hearing a lot more about these legal issues and a lot more about kind of possibility of war and these type of things, whereas we weren't seeing them 10 or 20 years ago. I think, again, that's a result of a newfound Chinese confidence in their economic power and their military power. You saw just 10 years ago, PLA Navy ships once every couple years kind of do a loop around Japan or pass through the route queues, and that was a big deal. And then it became a little more normal around 2009, 2010, and now it's something that happens regularly. It's become the way. And if you read through, again, going back to kind of this strategic extended deterrence issue and kind of operating in this gray zone in peacetime, and non-militarized coercion is what some have called it. I think you turn to, and John's written a book on this, you turn to legal tools as a means to help, your broader strategic agenda. This harkens, I guess, to the three warfares, as the Chinese call it, and using those tools of legal warfare and psychological warfare to help push that agenda and build, use your own ambiguity, a strategy of ambiguity to build and sort of slowly advance that agenda. And that's why, and if there's a lesson, Ukraine hasn't come up yet, or I guess I'll be the one to bring it up. If there's a lesson, I guess, of Crimea, it's not necessarily that, this issue pops up and, oh my God, what do we do not to stop this? It's that we clearly weren't thinking 2, 3, 4 or 5 years ago and setting, the basis for ensuring something like that doesn't happen. And so where these little pop-up issues may not be a big thing here in Washington, and they are a big thing in Tokyo or Seoul or Taipei, for instance, or the Philippines, we have to ensure that we're kind of staying on the ball and pushing back in ways that are messages that are getting through to Beijing, I'd say.
Thank you very much. I'd like to open it up now because I know there's a lot of expertise and a lot of folks with good insights and questions. We do have a mic, so if you have a question, just please raise your hand and identify yourself, let us know who you are, and then ask the question to our panelists. Who would like to go first? Sir?
Yes, Dave Fitzgerald, retired Foreign Service. A couple of questions, if I may. One on the what do you call it, the Asia Pacific Defense Readiness Bill? Is that?
Regional Priority Act. Sorry.
Regional Priority Act, sorry. A couple of weeks ago, there was a discussion at the Heritage Foundation where they were making a case for a more aggressive or activist U.S. government position to prepare legal briefs about disputes in the South China Sea, where we don't take issue on the sovereignties there, but we could set out some precedents for good international law. Does that effort in any way dovetail with what you might have been thinking of in this Defense Priorities Act? The second question, if I may, is more of an international law. Go back to maybe Professor Yu's comments. I've heard Japanese defenses of their claims, and they cite, I'm not an international lawyer at all, but these people were giving their views of international law or legal scholars. They talk about, you go back in international law, you go back to the last legitimate claim that's been established. And both parties seem to go back to some point when the claim was first made. It isn't just, we have a map here, or I could see it from my, my grandmother's house one day, and that's the basis of a claim. You go back to something that really establishes sovereignty. So you have something like, I don't know whether there was ever anything on ducto that might have shown that there was, it was part of Japan or not, but there would be something that they would presumably find to establish that, and then Koreans would establish it or try to counter it or whatever. Same with the Senkakus, and when did the Chinese really challenge this dispute, or challenge the claim, or exercise their sovereignty over those islands? If you're going to proceed on international law, I think you have to have something like that. My understanding is the Japanese are more willing to go to the court if you want, but that neither Koreans or Chinese are really hot to do this. You know, preferring perhaps the more legitimate purposes of this, the psychological warfare that they want to inflict on the region.
Well, on what happened at Heritage, which I'm not totally aware of, I do know their Asia Studies group pretty well, though, and some of the perspectives they would take. Where we were coming from with this Regional Priority Act was really to take what we had learned in 6 months and into a bill of a variety of provisions. And so some are meant for reassurance, others are meant to clarify further for the Congress, for instance, the quality and the quantity of the munitions that PACOM needs in the next 10 years, more specific things like that. But when it comes to, I guess, the broader point of your question, this is something that I think it's come up in some of those hearings we did, how to operate, how to deter in that gray zone. Eli Ratner at CNAS has done some good work on this and talking about, how do you raise costs in an environment of coercion short of conflict? And there's certainly a checklist of things you could be talking about that at least the press has been reporting, we are considering at a diplomatic level, at a PACOM or a military level, being less ambiguous in some of these territorial claims. That's certainly on that list. Whether you do that or not, that's a tough one for consideration. There was a Wall Street Journal article earlier this week, I guess, during the president's trip about a broader plan, I guess you could call it, that's been put together for signaling, classic gunboat naval diplomacy when the United States and its partners and allies want to push back. So anything from what we saw last year with the B-2, flying over Korea when the peninsula was hot, to carrier exercises in the Yellow Sea, something that we know the Chinese don't like, and they would pay a diplomatic cost for having to watch off their coast. And so I'm not privy to those conversations, but if that's happening within the executive branch, I think that's the kind of conversation that needs to be happening to ensure we have the right tools, again, back to the legal stuff and the other issues, short of conflict in the peacetime area, where we can be finding ways to push back.
I think just to add to that too, in your question, I think we were trying to set a baseline and really say, here's where we're coming from on the South China Sea specifically, where there's been speeches given that outline ideas about where the United States stands, but to really put something out and say, this is where the U.S. Congress stands, that we wouldn't support a change in the status quo by coercive means. We look forward to working with regional institutions to strengthen some of the things that they've done. If you look at organizations like ASEAN and what they've done with Code of Conduct in the South China Sea, whether that's upheld or not, to support some of those initiatives that have been laid out and really set a baseline for where Congress is at with some of these disputes, where there hasn't been sort of any a public baseline document to refer back to.
That's a very good question on international law you ask. So I don't believe you when you say you're not an international lawyer. Because it refers to this very complicated legal issue about what is the act that establishes sovereignty, and then you look at it, is it the law at the time you took the act, or is it the law now? So that's why conquest at the time that Japan seized the Senkakus in 1895, or when they seized Dokdo in 1905, back then you could have said it's legal under international law to conquer other territory. Right? There was no Treaty of Versailles at the time. There was no League of Nations. Law had not been outlawed at that time. So, Japan could have based its claims on that. That might be a stronger claim. And I was trying to get remarks is the reason you can't ultimately rely on that is because of the World War II settlement and this statement by the Allies that Japan would have to give all conquered territory back. Otherwise, it would have been a much stronger claim than this terra nullius claim, which I think is a very weak claim. So but when you make it a terra nullius claim, then you really do go back and say, who found it first? Was it ever found at all? Was it sort of unknown? And so if you look at the legal positions of both of all three countries, they actually spend a lot of time going through the historical archives of their own countries and everyone else's countries to find, was there ever any mention of our government sending anyone there? Were any of our citizens ever there? And if you look at the chronology with Dokdo, the Koreans first claimed contact with the island in the 1000s. Japan first claims contact in the 1660s. I could get the exact year, but in the 1660s. And so their arguments about Dokdo really have to do with, do we think they're really talking about the same island and they didn't have Western cartography and maybe they're talking about some other island? But if you just take their claims at face value, it's hard to say it's terra nullius because even the Japanese archives claim that even Japan found the island much earlier than 1895. Senkakus are more, I think, less complicated in that I think there's a lot of evidence that the Senkakus were known. And it's really a question of did China fully exercise sovereignty over it, and then did it give it up in the 1895 treaty when they gave up Taiwan to Japan? Did the Senkakus kind of go along with that concession? But I think, I haven't looked at the original, I have looked at the original source documents on Dokdo. I haven't looked at them with the Senkakus, but doesn't seem to be as much dispute about what the facts are with the Senkakus. There doesn't seem to be as much claim that nobody knew that island was there. With Dokdo, there is more of an argument about when did people actually first find it. Oh. Yeah. You're talking about the Senkakus. Yeah.
There's actually that
Yes. Yeah, I agree. Yeah, that's the terra nullius argument. When I say terra nullius is this weird Roman law. Actually, it goes all the way back to the Roman Empire, and it was a theory about how does a country get land. And one way was nobody was there, and no government claimed it, and so terra nullius means basically unknown land. And so I think you're quite right. The Japanese argument has to be to get around the World War II settlement, that they found the island and they incorporated it even before the conquests in 1895, because then they don't have to return anything pre-1895.
It gets to something that we did talk about in Berkeley, which is unique to Japan, and since we're deep into history, we'll just continue down this path and then dig our way out. But a couple of things. One is that so first of all, Japan, this is not something new to Japan because it lays claim to literally thousands of islands, some extremely large and well known, and others very small. And they do the same thing and have done the same thing with all of these, which is go back into the archives, and you're looking for all different types of evidence, as John mentioned, but not even evidence necessarily of government intervention. But for example, was a fisherman given the right to fish in these waters, or recognize that he was even in contact with these waters? And some are very large. For example, the Tsushima Islands, which also lie midpoint between Japan and Korea in the Korea Strait. But more interestingly, in the Japanese case, and this really, John, thank you once again, brings me back to my teaching days. In Japan's case, prior to 1868 and the Meiji Restoration and a centralized government, you had a feudal system in which what we call the central government never really claimed centrality, being a central government over Japan, the Tokugawa shogunate, the Bakufu. But what they did claim was control over foreign relations. And so sometimes what they would do was not recognize the claims that any of the feudal domains had made on territory outside of Japan, because to do so would have been to recognize those domains' ability to have independent foreign affairs. So some of the evidence that Japan could use, potentially, to say, yes, these were islands that we had control of or knew in the 17 or 1600s or even earlier, the central government would specifically not allow that claim because that would raise questions of its own authority over foreign affairs. So that complicates some of the issues because they would draw their maps that way. They would not include these territories because they did not want them seen as territories that they did not directly control. Only if they had the control would they include it on the maps or have documents that recognized it. And so for Japan, at least, because of the bifurcated nature or multifurcated nature of its feudal government, it's actually an even more interesting set of legal questions, which, of course, in 1868 onward, the government really wasn't thinking about because, as John said, it was a period where conquest was simply accepted, whether it was Formosa, Taiwan, or Korea as a landmass, or the islands associated with it. So,
Can I just make one comment? I didn't understand this until I heard you make this point, but I think that's borne out, at least in the Dokdo example, and I think it is also involved with the Senkakus. But with Dokdo, there are documents in the Japanese archives that Korean scholars make a big deal about, where the central government says the border does not go past Oki Island. Stop trying to, they're directing a province, basically, stop trying to claim these islands that go beyond Oki. And I had never understood, why would the Japanese central government make, self-limit itself in this way? And it wasn't until I heard this explanation. But you see that dynamic in the actual historical documents. The thing is, in international law, it's very significant, because if a government ever says, we're giving up a claim to this island, even if you change your mind later, legally, it's very important that you at one point said, no, we don't think we actually have sovereignty over this island. It's almost like in the law, you waive a claim, it's always waived. You can't take it back later. And so those documents, statements that Misha's talking about, are extremely significant for the international law claims.
Hi, thank you. My name is Zhang Zhu with the Legal Daily China. Thanks for the presentation. I have two questions. One is on the Senkaku Islands. I just have some short comment that I don't think this issue, specifically on this issue, is not so complex or difficult. There's a documentary film recently shot.
I don't want to interrupt, but we'd like to ask
Very
a
short,
question
very
and not
short.
make
Yeah.
a statement, please.
It's
Thank
shot
you.
by a Hollywood director, an American, not Chinese. I recommend you to see it very clearly. It's available on YouTube, namely Diaoyu Islands, The Facts. It's very clear. My question to Professor Yu is that I think now U.S. is also facing this kind of problems. I just wonder, is that a better way for U.S. to fully recognizing to gain the credibility of our leadership in the region by fully recognizing the historical documents, like the Carroll Declaration or Boston Proclamation? And the second one is for Eric and Sean. Actually, this question raised by Michelle in your article. President Obama just finished the visit in the region. Do you think the visit will contribute to de-escalation the tension here, or make the situation even worse? But I just mentioned one thing, that China and Russia will conduct joint exercise next month. This month, sorry. And they moved the area closer to Diaoyu Islands. I mean, they just changed the plan. So I just want your comment on that. Thank you.
This is a sort of combination of a legal political question you asked me, and the lawyer in me says that the reason, and this actually I think is similar to some of the points that Eric was making and Sean were making, is that because there is this ambiguity in our policy, because there's no clear statements from our executive branch, that's why you're seeing the disputes flare up in a way. Because if the United States is sort of, these guys are international relations guys, and so they're, they think of the U.S. maybe as a hegemonic power that's establishing the rules and so on. When that's, from a lawyer's perspective, when the rules start to break down, that's when you start seeing disputes flare up, right, with this one. So if the United States was playing a leadership role, you shouldn't see a lot of fighting over Dokdo, right? Because you have two allies who are taking some fairly aggressive measures against each other. It doesn't make sense if, you do have a rule-setting larger power. And then the Senkakus is a similar, I think, that if you had more secure, if Japan was more, more confident in the security relationship, or you might not see as much, right, Japan-China friction, perhaps. And so the legal perspective is like, I would, one way you could establish some kind of leadership would be a bargain, and it's very difficult between China, Japan, and Korea, where the United States would be something of an honest broker, because we really, as Sean was saying, we really have an interest to make sure there's no military conflict in the region, just for economic reasons, putting aside just the political reasons. And so, I was saying, pre-20th century, this was actually something that would happen, is that you would have these kinds of disputes, and someone would go to the leader of a foreign country and say, we're laying it all before you, and we all agree to be bound whatever you come up with. Now, maybe the United States might not be the trusted country to play this because we have our own interests, but the United States could play something of a role which requires more policy statements and guidance to try to say this is the solution that would be best interest of all three countries together, and then try to move them towards it. And it would be partially one that addressed the legal claims as well as the security claims. And then just the separation of powers point, someone's worked in all the different branches of government. If the executive branch isn't going to do it, this is an area where Congress can play a very significant role in foreign affairs, where they don't have to, it seems to me, just follow what the State Department line might be, because Congress has a right to pass resolutions and statements and study the problem for themselves and have a different point of view.
Just briefly, maybe Sean wants to add on the trip. I'd asked, your first question was the trip successful in reducing tensions? I'd add a corollary, was it successful? In terms of tensions, I don't know if the president, I see this as a longer term competition in peacetime, and so I don't know, maybe in the coming weeks and months, we won't see, the Abe, Obama relationship has strengthened, and maybe we won't see another Sekuni shrine visit, which might contribute to more tensions. You might be able to make that case, but the broader question of, was it successful in those terms? Was it, if you see China and its activity as being kind of the contributor to the instability in the first place, and that is how I view it. I would say it's mixed, and that's kind of the academic answer, but I think the president, from the president's perspective, coming out of Tokyo without the TPP agreement was seen as weak, was not a strong play. But I do think before he left, that interview he did in Yomiuri Shimbun, or Sahi Yomiuri, that was very much aligned with, where at least where the Congress is, certainly where Tokyo is. He hit all the right points. So in terms of being successful, I think he did, by saying I want to go and reassure our allies, I think he did achieve that goal. Obviously the agreement too with Manila, that's just as the agreement in one of the previous trips, November of 2011 in Canberra, on access in Australia. I think this agreement with the Philippines is kind of a continuation of a trend that the United States, the Chinese behavior is pushing these countries into the United States orbit. I don't think Manila would be willing to do what they did in this agreement 2 years ago, certainly not 3 or 4 or 5 years ago and before that. These are just kind of the continuation of the fallout, I think, of what Chinese actions and behavior has wrought. And so I do think, from a stability perspective, that is something that breathes a breath of fresh air into what's going on in Manila and the Scarborough Shoal. Again, we haven't talked about that. That's not the issue at hand today. But I think these need to be looked at as issues that are connected to one another. By reassuring Japan, I think that's reinforcing Manila's spine in this competition, as well as how Southeast Asia views U.S. staying power. I'm not sure if Sean has it.
Yeah, I would think I would agree with Eric mostly. Was it successful? I'd say yes. Could it have been more successful? Sure. I think that President Obama set out what has been his policy and what he set out to do on the trip: reassure 2 of our treaty allies in visiting Japan and the ROK, and then place greater emphasis on countries in the South China Sea, which, echoing what Eric said, the agreement with the Philippines, the visit to Malaysia, I think he did what he set out to do. Whether I don't think it's completely fair to evaluate the actual success of the trip on this short of notice, as he just got back. We were caught in his traffic actually on the way over here, so I think it leaves to be seen. I think more can definitely be done, but he did what he set out to do. So I would say it could have been more successful, but from a standpoint there, it was.
Other questions? Yes, sir, over here.
John Sheldon, the Torridon Group. Question primarily for Mr. Callahan and Mr. Sayers, although Professor Yu may have some comments on this as well. Talking to Japanese officials, and also aware that there are discussions going on between the US and Japanese governments on this, maritime domain awareness, in particular space-based maritime domain awareness, is something of particular interest to both governments. Is this something that you're aware of on the Hill? Is this something that you would think would be a good idea in terms of expanding cooperation, which Mr. Callahan mentioned in the region, but also shedding some sort of transparency over the strategic geography that Mr. Sayers talks about that might buy political diplomatic space for perhaps resolving some of the more immediate issues surrounding these territorial disputes?
Yeah, thanks for that question. Maritime domain awareness in general, but obviously the space angle of it, that's a critical part of it. It's just like understanding situational awareness in cyberspace or space situational awareness. These are critical elements of deterrence and reassurance. On the space side, the Japanese passed, I'm sure you're aware, an important piece of legislation a couple of years ago, maybe 5 years ago now, that kind of put them along this path. Small caveat, when I was in Japan last in February, we met with some of the Mansfield fellows that are over there, and one of them was from our State Department, and she's in yeah, exactly. You're very well in touch with these. She was there from our State Department space office, just working in a variety of Japanese offices. To me, we talked for a couple hours about this. That's kind of a signal of the deepening interest from the Japanese side and from our side in helping out the Japanese in that area. The broader ISR kind of question, this is one of the real things that Japan deserves credit for, and kind of back to our budget question that I was discussing earlier. Whereas Abe-san is increasing the defense budget, in real terms, he's also in his NDPG really prioritized some of the areas that need to be plussed up, not just in ISR but also mobility. But the ISR side of Global Hawk, probably more BAM's Triton, the maritime variant of Global Hawk, and some of the other initiatives that are kind of going on behind the scenes. That's all something that Japan needed to invest more in, especially for understanding just what's going on down in the Southwestern Islands. The Coast Guard from Chinese activity and the Japanese Coast Guard folks that I've talked to, the pace of operations just becomes so high that it's exhausting to keep up, exhausting the manpower, exhausting the more minimal capabilities. Maybe Misha can say a bit on this, as I had some of these same conversations. And so it's a kit thing as well. It's having the Coast Guard and the JMSDF platforms that can be up there. And I think that's why they've made a good decision in going down the UAV side of this. Global Hawk can certainly get at some of that, but I think there's some other unmanned capabilities they can be looking to that are perhaps a bit smaller that can contribute to that as well.
And I'd be remiss if I didn't take every opportunity to plug the bill that we just introduced. But there were two specific provisions in there that get to maritime domain awareness. One was an increase in authorization for space situational awareness, and the other was the establishment of the DoD Unmanned Systems Office, which we see playing a critical role in sort of formulating the policy and the oversight and planning long-term to actually get to the fruition with the ISR assets that are needed to monitor an area that's the biggest COCOM on the world, and when we look at the surface fleet numbers not expanding as rapidly as maybe they should, that they can really make up for the gaps in the capabilities of the maritime domain awareness. So,
a comment more on what they said to you than the original question, which is not really my area, but the things you're describing are very important for international law purposes. This kind of constantly testing the other side, forcing them to send their own ships, which, from military side, I know you worry is going to cause some unforeseen clash. But from international law, it's extremely important that you do this because, they always say possession is 9/10 of the law, but in international law, right, you discover the islands and then you continue to exert control. And so and right now Korea possesses one, controls one, and Japan controls another. If you were China and you want to contest the Senkakus, you would continuously send, that's what I would do to test their international law right, would be, let's see if we can get them to withdraw from the island. It's too expensive to keep sending your ship every time you send your own ship. You have to do that, though, to maintain your legal claim. Yeah, and whereas with DOCTO, there's some examples of that, but Japan doesn't really do that to Korea. They're not constantly sending flights over the island. They're not sending ships every month, circling. Maybe they do it every now and then, but it's more like a flag waving exercise than a real testing period. And so to me that, if you look at this question, the international aspect, and it seems like, there's really a dispute over the Senkakus and China. Again, it's the thing that impresses me, just trying, they are contesting it strategically, but they're channeling it in a way that really counts for legal like it helps their legal claim a lot to do it the way they're doing it. Whereas with the Japan-Korea dispute, I think Misha actually has a stronger view on this. It seems like Japan doesn't really mean it to me. Maybe they do when they say it, but they don't take the actions that they, that seem to characterize the Senkaku's dispute.
Hi, Shirley Khan with the Congressional Research Service. I want to ask Mr. Yu a question that pertains to these different disputes, but since you're here and talking about international law, quick question. As people have mentioned today, the Cairo Declaration. Does it have any status under international law? It does not, right?
This is a really interesting question, but the Cairo and Potsdam, because you could say, and this is sort of why I was saying that the 1951 peace treaty is so weird and open-ended, and a lot of things are left unsettled. So, if you read the text of the 1951 treaty, it doesn't specifically mention Dokdo. It only, you could say the Senkakus are included because there's a line that's demarcated in the treaty south of which the United States controls for occupation, but not for transfer of sovereignty. Yeah, right. Yeah, but most importantly, I think even more importantly, that China and Korea don't sign the treaty, right? They can quite honestly and legally say we're not parties to it, so we're not bound by anything that the U.S. and Japan agreed to in 1951. So because the treaty is so open-ended and leaves things unsettled, people go back behind it to look at Potsdam and Cairo because they say this is what the peacemakers were trying to do. It's like their declaration of purposes. You can also say it's like the way we think of the Declaration of Independence. The Constitution is really the legally, implemented document, but sometimes we look at the Declaration of Independence to figure out what they were doing. The other way Cairo and Potsdam kind of come in is that when Japan surrendered, right, they mention the documents and the instrument, these principles in the instrument of surrender. Again, they don't have the specificity of a legal document, right? They don't say these are all the things you're going to return at the end of the war from Japan to the other countries. They just say you will just return things that you seized, through aggression, right? And it's hard to give that real legal definition. But because you don't have the specificity on all the issues in the 51 treaty, it's a very common legal thing is to go back to the precursors and try to see, did the spirit of it keep continuing through to the 1951 agreement?
I think we have time for maybe one more. If someone has another.
Yeah, Luke Strange, I do work here at AEI. I wanted to ask Eric and Sean, based on things that you guys said earlier, about building a capacity in Congress, structurally with staff and with hearings and the things that your bosses did. Building on that, have you seen a similar shift in the executive branch in the interagency process? Obviously, your bill tries to take steps with the Defense Unmanned Systems Office and other mechanisms. Do you see a shift as being necessary just in terms of processes and people, personnel being policy in some ways? And do you think such a shift is necessary?
I mentioned a bit just the committee structure, but one of the things in that lane that, John served in government, it's all about relationships. And so our ability to really understand our own situational awareness of what's going on at the NSC and the Pentagon is relationships, because a lot of that on the normal tracks with ledge affairs over with us can be very, very stiff. And, here's your PowerPoint brief and this is the way it is. And so one of the ways that our office and myself, we've been successful, I think, is kind of building those relationships at places like AEI and think tank world that we can leverage and come to for advice. And a lot of these folks that I know of places, other think tanks have gone into this administration. I'd say too, on the House side, one of the things that we've kind of informally set up over the last 6 months, there's sort of an informal group of Senate and House staff Asia hands. You've got some folks who've served in government, like Mike Schiffer and SFRC, and Carolyn Letty, who are the Asia leads at SFRC, and some other interested MLAs on the Senate side, and some of the folks from HVAC and HASC, and then a few of the other MLAs or or LAs that do foreign policy issues, and there's probably 20 people or so on that list who are engaged on these issues, not just because their bosses are or their job dictates it, but just have worked in the region before. And so we've been setting up lunches. We've done a lunch with Ambassador Beasley, Ambassador Sasai. We're doing one with the new Taiwanese ambassador. We've done a couple classified briefings with different people from DoD, and so we think that network of just like-minded staffers kind of coming together and putting their minds together is a good way to really move the ball on that.
Yeah, I would just add, I think it was said earlier, but, the most visible part of the rebalance to the Asia Pacific, whatever you want to term it as, is definitely the military, because that's what you can see. I think if you look even at President Obama's most recent trip, the most notable thing that came out of it were military agreements, and not as much on the economic or diplomatic side. So, but, it speaks to what our bosses can affect from the Armed Services Committee. It speaks directly to the military. And I think that what we're encouraging by trying to get a document like that put together is a whole of government approach. And in a central place where people can go back and say, what's the plan? And you can hand them a piece of paper and say, this is the plan. I think it's necessary because the engagement and successful engagement in the Asia Pacific is not just military. It encompasses an economic and diplomatic side as well. So.
Again, on the people side and in those relationships, where we've stumbled the last year trying to get the NSC to do an Asia review. There is an opportunity now with DoD. Maybe you have the right people aligned. You've got a new ASD chair who knows the region, who seems excited about it. You've got just yesterday now nominated and confirmed Bob Work, who was talking on an Asia panel at the Reagan Defense Forum that the Chairman McKeon put on out at the Reagan Library last November. He was on an Asia panel and talking about these issues in the department and his thoughts on it. I think with maybe those two individuals is an opportunity to, if we're not going to get a good product from NSC to do like they did in the 90s, like Joe Nye and Kurt Campbell and some of those guys did in the late 90s. I think they did 2 or 3 variations in East Asia strategy review. So that's something that we may just have to send a letter and they'll say, hey, we were already thinking about that. Let's go ahead, and then we've got congressional support. So there's an opportunity there.
That's great. Well, we have hit our time. I thought this was really a great discussion. We covered legal issues and history and the policy, and thanks to Sean and Eric, the sort of forward-looking role that Congress is playing and can play even more of, and regardless whether it's a Democratic or Republican administration, they're all stressed and filled with millions of things to do, and there really is a role for Congress to play and guide and shape and have oversight, and I think that Sean and Eric are going to be at the center of that for a long time. John, thank you for bringing this roadshow here to DC. Thanks to all of you for joining us, and I'm sure that we will come back and revisit this at some point in time. Thank you.